Let's go back to this story. We've told you about the anchorwoman from Little Rock, Arkansas, Ann Presley, brutally attacked, raped, and left for dead in her home. This was back in October. Well, today, the alleged killer and his team of lawyers faced a judge. Let's bring back Rochelle Carey with a little more on that. What was going on with the lawyers, Rochelle?
Well, Mike, Curtis Vance's lawyers, they are claiming he was interrogated by police twice without an attorney present. His lawyers, obviously, what it is they're worried about that Vance could, maybe he said something that could hurt him in court. So they filed a motion to ban police from meeting with their client. And they also asked for a 48-hour notice when police re-question him. The judge said no. The judge disagreed, saying it's up to Vance if he wants to speak with police with or without legal representation. Prosecutors say, hey, he's the one that requested the interviews and waived his right to an attorney. Vance is charged with capital murder, rape, burglary, and theft in this case, Mike.
Okay, Rochelle, thanks for that. Okay, that sets the table for us. So did the judge make the right move here? Joining us to talk about it, criminal defense attorney Nicole DeBoard. Also with us, Conrad Claus, a former prosecutor. Okay, prosecution, Conrad's claiming, correct me if I'm wrong, that he waived that right. He called the meeting with police.
That's what they're saying. They're saying that he actually initiated the contact. And in that sense, if you want to come clean as a defendant on a case, you don't need your attorney there. Indeed, your attorney cannot invoke your rights on your behalf. So the fact that they filed motions or they made noise in front of a judge is completely and utterly irrelevant. Apparently he wanted to talk to the police not once but twice, which fits in line with his prior history. He agreed to a saliva swab without a warrant. He also agreed to a search of his house. This guy seems to want to cooperate.
Okay, so he must have said some pretty damning stuff, right, Conrad?
That'd be my guess.
Yeah.
Typically, when people start talking in these interrogations, they don't stop until they've given the police everything.
Okay. Conrad Claus, former prosecutor. Conrad, let's go to you, picking up the point Nicole was making. So how are we going to definitively find out whether or not that Sixth Amendment right was violated?
Well, first off, I don't think it really takes much to uninvoke it, as was suggested. All you need to do is say, officer, I want to talk to you. So there doesn't have to be a big record or any long back and forth. It can be as simple as that kind of short, independent clause. Secondarily, we don't have any indication he ever invoked his right to remain silent, actually. At least I've never seen it.
Okay.
So I'm not even sure we even get to that point. But the fact is, again, if he made that simple statement, officer, I want to talk, that's it.
Can the suspect still be tried based on the DNA evidence? Conrad, can you handle that one? So you're only... Go ahead.
Yeah, absolutely. He's already suggested that the DNA evidence was taken illegally, and that's not accurate, actually, at least based upon the evidence that we have. Can you go straight on that DNA evidence? Absolutely. There also appears to be other evidence insofar as his girlfriend was out pawning stolen material, and we probably have a common scheme or modus operandi that's acting in this case. The police already believe this was a robbery that went wrong.
Okay. All right, guys, we're going to have to leave it there. Nicole, Conrad, appreciate it. More Prime News coming up. Stay with us.